All right, let's dive into something pretty big happening in Florida. We're talking about those huge changes to the rules of civil procedure that just kicked in. January 1st, 2025. New year, new rules for the courts, right?
Yeah, no kidding. It's a pretty big shift, and I think a lot of it is about trying to make things more efficient. Make Florida's courts work more like federal courts.
Interesting. So efficiency is the name of the game. But will it actually work? I guess we'll see.
Exactly. We'll have to see how it all plays out in practice.
Okay, so where do we even begin? There's so much to unpack here.
Well, how about we start with one of the biggest changes, case management tracks. This is a big change from how things used to be.
Case management tracks. That sounds kind of complicated.
It's not too bad, really. Basically, every case now gets put into one of three tracks, streamlined, general, or complex. And it's not about how much money is involved. It's about how much attention the case needs from the judge.
Okay, that makes sense. So what kind of cases would fall under each track?
Let's start with streamlined. These are the more straightforward cases, like small claims cases, maybe uncontested divorces, or a simple breach of contract case where everything's pretty clear-cut. Limited discovery, established legal issues, and a trial that shouldn't take more than 3 days.
Gotcha. So streamlined is for the quick and easy cases. What about general?
Yeah, general is kind of the catch-all category. If a case doesn't fit into streamlined or complex, it ends up in general. Most typical civil cases will probably land here.
And then complex. Those are the real doozies, right?
Well, they definitely require more attention from the court. Think cases with multiple parties, like a big lawsuit with lots of people involved, or cases where you have to coordinate with courts in other states, or maybe cases with tons of pretrial motions flying back and forth.
Okay, so those are the three tracks. Streamlined, general, and complex.
Hmm.
But how does a case get assigned to a particular track? Is it set in stone?
Well, the judge decides which track is appropriate, but the parties can ask for a change if they think it's the wrong fit.
So there's some flexibility there. But they better have a good reason, right?
Yeah.
I mean, judges probably don't want to be messing around with track changes all the time.
Right, they're not going to grant a change just because someone's trying to slow things down or avoid deadlines.
Speaking of deadlines, those are a big part of these new rules, right? Things are going to move a lot faster now.
Yeah, absolutely. Time management is key. Procrastination is not going to fly anymore. Judges have to issue case management orders, what we call CMOs, within a pretty tight time frame.
CMO, can you break that down for our listeners who might not be familiar with legal jargon?
Sure. A CMO is basically a roadmap for the entire case. It lays out all the key deadlines, when discovery has to be completed, when motions need to be filed, even the date of the trial.
Okay, so it keeps everyone on track. And the new rules say those deadlines are meant to be followed strictly, right?
Absolutely. No more leniency or Florida time, as they say. Extensions are going to be much harder to get.
Wow, that's a big change. So what does all this mean for lawyers and their clients? It sounds like they're going to have to be a lot more organized and on top of things.
Exactly. Early preparation is more important than ever. No more waiting until the last minute to get things done. Lawyers will need to be proactive and strategic right from the start.
No more leisurely strolls through litigation. But what happens if something unexpected pops up and a deadline can't be met? Say, a crucial witness is suddenly unavailable, or there's a delay in getting important documents.
Well, communication is key. If a deadline looks like it's going to be a problem, the first step is to talk to the other side's lawyer. See if you can work something out, maybe agree to a reasonable extension.
So pick up the phone and try to resolve it amicably.
Exactly. But if that doesn't work, then you have to file a motion with the court, and it can't be some vague last-minute request.
No more, my dog ate my homework excuses, huh?
Right, exactly. The new rules demand a lot more detail. You have to explain exactly why you need more time, when you realize there was a problem, what steps you're taking to fix it, and what the new deadline should be. You even have to check if any witnesses or experts are available on the proposed new dates.
Wow, so they really want you to dot your I's and cross your T's. Sounds like judges are going to be cracking down on anyone who isn't taking deadlines seriously.
Definitely. Remember, efficiency is the goal here, and that means keeping cases moving forward at a steady pace.
All right, so we've talked about case management tracks and those stricter deadlines. What about discovery? Are there any major changes there?
Oh, absolutely. One of the biggest changes is the introduction of initial disclosures. It's something that's been standard in federal court for years, but it's new to Florida.
Initial disclosures, what are those exactly?
Basically, you have to disclose a bunch of information up front within 60 days of being served with the complaint or being added to the case. You don't even have to wait for the other side to ask for it.
It's like showing your hand right from the start.
Exactly. Transparency is the idea here. You have to disclose things like the names and contact information of anyone who might have important information for the case. You also have to provide a description of any documents that might support your claims or defenses, how you calculated your damages, and any insurance policies that might be relevant.
And there are no exceptions to this rule. What if you haven't had time to fully investigate the case yet? Or what if the other side hasn't provided their initial disclosures?
Nope, those aren't valid excuses. The rule is clear. You have to make those initial disclosures on time, regardless.
So it's all about getting things out in the open early on. No more playing hide and seek. But wait, it doesn't end there, does it?
Yeah.
There's also this new duty to supplement.
That's right. If you learn new information or get a new document that's relevant to the case, you have to turn it over to the other side, even if you've already responded to a discovery request.
So no more holding back information until the last minute.
Nope, you've got to keep things updated. This continuous disclosure requirement is a big change, and it's meant to make sure everyone has the most up-to-date information.
And this applies to all types of discovery, right? Not just those initial disclosures.
Exactly. So if you send out written questions, called interrogatories, and get answers back, but then later find out that an answer was wrong or incomplete, you have to correct it.
I bet that's going to keep lawyers on their toes.
It will for sure. It adds a layer of complexity, but the goal is to make the process fairer and avoid any surprises at trial.
Okay, so we've covered case management tracks, those super strict deadlines, initial disclosures, and this new duty to supplement. It's clear that discovery in Florida is undergoing a major overhaul. But there's more, right? What about the scope of discovery itself? How's that changing?
Yeah, that's a big one too. It's not just about the timing of discovery anymore, but also about what information is considered fair game. And here we see a clear effort to limit some of those overly broad discovery practices that had become common in Florida. That old anything relevant standard is gone.
So no more fishing expeditions.
Exactly. Now, for something to be discoverable, it has to be relevant to the specific claims or defenses in the case. And this is where the concept of proportionality comes into play. It's a concept borrowed from the federal rules.
Proportionality.
Yeah.
That's the buzzword everyone's been talking about. But what does it actually mean in practice?
You can think of it as a common sense check on what information is truly necessary. Judges now have to weigh a number of factors before allowing broad discovery requests.
So they're not just rubber stamping every request anymore.
Right. It's about finding a balance between relevance and the burden of producing information. They'll look at the amount of money involved, the resources of each party, and whether digging up that information is going to be overly burdensome compared to its value to the case.
So it's not just about whether something is technically relevant, but whether it's worth the time, effort, and expense to get it.
Exactly. And I think this could really help level the playing field, especially in cases where you have a small business going up against a huge corporation with tons of resources.
That makes sense. But I can also see how it could be abused. Couldn't a wealthy party try to use this to hide damaging information by claiming it's just too much trouble to produce?
That's a valid concern, and that's why lawyers need to be ready to explain why the information they're requesting is truly essential and why the burden of producing it is reasonable. It's going to be a strategic game for sure.
So judges will have their work cut out for them, making sure everyone plays fair.
Exactly. And speaking of fairness, those new requirements for objecting to discovery requests seem like a step in the right direction. No more hiding behind vague legalese.
Yeah, we touched on that earlier. So lawyers can't just throw out those generic objections anymore.
Right. They need to be specific. If you're objecting to a discovery request, you can't just say it's overbroad or burdensome without explaining why. And that explanation needs to be tied back to those proportionality factors we talked about.
So no more blanket objections.
Nope. You have to provide context and justify your objections.
And what about those situations where you're objecting to a request and withholding documents? Is there anything new there?
Yes. Now you have to explicitly state that you're withholding documents and explain why.
So no more playing games with document production.
Exactly. This new rule promotes transparency and forces everyone to be upfront about what they're holding back and why.
Okay, I think we've covered a lot of ground here. We've talked about case management tracks, those tight deadlines, initial disclosures, the duty to supplement, the concept of proportionality, and the new rules for objecting to discovery requests. It's a lot to take in, but it seems like the discovery process in Florida has been completely revamped.
It has, and while there will certainly be challenges, I think these changes have the potential to make the discovery process more efficient, focused, and fair for everyone.
I'm sure we'll be talking about these changes for a long time to come. But for now, we're going to take a closer look at some of the other important aspects of these new rules in our next segment. Stay tuned.
Welcome back. We've been talking about all these big changes to Florida's rules of civil procedure, especially when it comes to discovery.
Yeah, it's a lot to digest.
It is, but one of the things that's generating the most buzz is this whole idea of proportionality in discovery.
Oh yeah, proportionality.
hmm
Honestly, I think it's got some people a bit confused.
I can see that. It's kind of a new concept for a lot of folks.
So, can we break it down a bit? What does it actually mean for, everyday people who aren't legal experts?
Sure. Think of it as a way to make sure the information requested in a case is actually necessary. In the past, you could ask for almost anything as long as it was even remotely relevant.
So like a fishing expedition, just throwing out a wide net and seeing what you catch.
Exactly. But now, judges have to look at a bunch of factors before they let those kinds of broad requests go through.
So it's not just about relevance anymore.
Right. It's about balancing that relevance against the burden and cost of actually getting the information. The rules specifically say judges have to consider things like how much money is at stake, the resources each side has, and whether digging up that information is going to be a huge pain compared to how helpful it actually is to the case.
I see. So they're trying to prevent one side from overwhelming the other with requests that are technically relevant but not really worth the effort.
Exactly. It's about making the discovery process more efficient and fair.
I like that. But I can also see how this could get tricky. Was to stop a party with tons of money from using this proportionality thing to hide information that might hurt their case. They could just say, oh, it's too burdensome to produce that, Your Honor.
That's a good point, and that's why lawyers need to be on their game. If you're requesting information, you've got to be able to explain why it's crucial to your client's case and why it's not an unreasonable burden for the other side to produce it.
So it's kind of like a chess match. Each side is trying to use this proportionality rule strategically.
Exactly. And the judges are there to make sure everyone plays fair.
And speaking of playing fair, those new rules for objecting to discovery requests seem like they'll help even the playing field a bit.
Oh yeah, no more hiding behind vague legal jargon. Those old standby objections like overbroad or irrelevant won't cut it anymore.
So you can't just throw out those generic objections without backing them up.
Right. You've got to be specific. If you're objecting to a request, you have to explain why, and you've got to connect your objection back to those proportionality factors we talked about.
So it's all about being clear and giving reasons. No more hiding behind legal mumbo-jumbo.
Exactly. And there's another big change, too. If you're objecting to a request and you're holding back documents based on that objection, you can't just keep quiet about it. You have to clearly tell the other side that you're withholding stuff and why.
Okay, so no more playing hide and seek with documents. Everyone has to be upfront.
Right. Transparency is key.
Got it. Well, we've spent a lot of time on discovery, but I don't want to forget about another big area where things have changed.
Yeah.
Motions for summary judgment.
Oh, yeah. Summary judgment motions. Those are the ones that can really shake things up.
Exactly. They can make or break a case. So what's different now?
The biggest change is that sense of urgency we've been talking about. You can't drag your feet when responding to a summary judgment motion. The deadline is no longer tied to the hearing date. Now you've got 40 days from when you get served with the motion, no matter when the hearing is actually scheduled.
So no more last-minute scrambling.
Nope, you got to be ready to go. It puts the pressure on everyone to be more proactive and strategic right from the start.
So as soon as that motion hits your desk, you got to start working on your response.
Exactly.
But doesn't this give an advantage to the person who filed the motion? They get to start the clock ticking, right?
Yeah. That's true, but the other side still has plenty of time to put together a strong response. And remember, both sides have to be prepared from the get-go. If you're thinking about filing a summary judgment motion, you can't wait until the last minute to gather your evidence and get your arguments in order.
Makes sense. So it's still a fair fight, but with a much faster pace. What about that new rule about communicating before filing a motion? How does that work?
This is a really interesting one. Basically, before you can file most motions, including summary judgment motions, you have to try to work things out with the other side first.
Wait, so you actually have to talk to the other lawyer before you file a motion?
Yes. You have to show the court that you've reached out to the other side, explain the issue, and tried to find a solution.
So no more shoot first, ask questions later approach.
Right. The rules are encouraging a more cooperative, less adversarial approach. The goal is to try to resolve things without clogging up the courts with unnecessary motions.
I see. So it's about trying to find common ground before things escalate. Do you think this will actually lead to more settlements or agreements?
It's hard to say for sure, but it's definitely worth a try. Even if it doesn't lead to a full settlement, it could help narrow down the issues, which could make the whole process more efficient.
Yeah, that makes sense. But what if one side just flat out refuses to participate in this pre-motion communication?
Well, there are consequences for that. The rule says that if you don't communicate, you could face sanctions.
So it's not just a suggestion, it's a rule with teeth. Judges can get involved if someone's not playing ball.
Exactly. And I think this shows how these new rules are really trying to change the whole culture of litigation in Florida. It's not just about following the letter of the law anymore. It's about being more cooperative and finding ways to resolve disputes efficiently.
I like that idea. So it's not just about winning at all costs, it's about finding solutions that work for everyone. But let's zoom out a bit. We've been talking a lot about specific changes, but what about the bigger picture? How do these amendments affect judges? It seems like they're being asked to do a lot more.
That's a great observation, and it's something that has a lot of people worried. Florida judges already handle a ton of cases, and these new rules with all those strict deadlines and the push for early resolution could really add to their workload.
That's what I'm concerned about. Will our courts, which are already super busy, be able to keep up with all these changes?
It's a valid concern. We could see bottlenecks in the system if judges don't have the resources and support they need to handle all this.
And what about access to justice? Will these changes make it harder for people who can't afford expensive lawyers to navigate the system?
That's a crucial question, and it's something we have to pay close attention to. The goal of efficiency shouldn't come at the cost of fairness. We need to make sure these changes don't make it harder for people to get a fair hearing.
So it's a delicate balance.
Yeah.
We want things to be efficient, but we also need to make sure everyone has a fair shot.
Exactly. And that means we need to be flexible and willing to make adjustments as we go. These rules are brand new, and we're all still learning how they work in practice. We have to be open to feedback and ready to tweak things if we see unintended consequences.
It's like a giant experiment, and we're all part of it. Speaking of experiments, I'm really interested to see how that pre-motion communication requirement plays out in real life.
Me too. Will it actually lead to fewer motions being filed? Will it change the way lawyers interact with each other? It's going to be fascinating to watch.
Only time will tell. But one thing's for sure, these new rules are a game changer for civil litigation in Florida.
Absolutely. It's a time of big changes, and everyone involved needs to be ready to adapt.
We've been digging deep into all these changes to Florida's civil procedure rules, but I want to step back and think about the big picture for a minute. You know, a lot of these changes are based on what they do in federal court.
Right, that's true.
But I'm wondering if what works for federal courts will always work the same way here in Florida. Our state courts are a whole different animal, right?
Yeah, that's a good point. Florida's legal system has its own quirks, that's for sure.
For instance, federal judges don't have nearly as many cases on their plates as our state court judges do. And they've got way more resources, more staff, more clerks, bigger budgets, the whole 9 yards. Can our state courts really handle all these new demands on top of everything they're already dealing with?
It's definitely something to think about. Everyone wants things to be more efficient, but what if it backfires? What if we end up with even more delays and backlogs because the courts are just overwhelmed?
That's what I'm worried about. It's like we're trying to fix one problem, but we might create a whole new set of problems in the process.
Yeah, and we have to think about the impact on regular people too, folks who might not have a lot of money to hire fancy lawyers. Will these changes make it harder for them to get a fair shake in court?
That's a really important point. We want to make the system better, but not at the expense of fairness and access to justice.
Exactly. We have to be careful that these changes don't accidentally create barriers for people who are already at a disadvantage.
So it's a balancing act. We want things to be efficient, but we also need to make sure everyone has a fair shot.
Right. And that might mean we have to make some adjustments along the way. These rules are so new, it's like we're all figuring it out as we go.
It's a giant experiment, and we're all the guinea pigs.
In a way, yeah. But that also means we have a chance to learn and improve. We need to pay attention to how these changes are working and be ready to make tweaks if necessary.
Absolutely. We can't just assume that everything will work perfectly right out of the gate.
And one of the things I'm really curious about is that pre-motion communication requirement. It's a pretty big change.
Me too. It's a bold move, that's for sure. Do you really think it's going to work? Will it actually cut down on all the motions flying back and forth?
I don't know, it's an experiment, like we said, but I'm hoping it will at least encourage lawyers to be a little more cooperative, to try to work things out before they run to the judge every time they have a disagreement.
Yeah, that would be nice. A little less fighting, a little more problem solving.
Exactly. But we'll see. Human nature being what it is, I'm sure there will still be plenty of legal battles.
Well, one thing's for sure. These new rules are a game changer for civil litigation in Florida. It's a whole new ballgame.
It is, and everyone needs to be ready to adapt. Lawyers, judges, clients, everyone. This is a whole new world we're stepping into.
Well said. I think that's a good note to end on. To everyone listening, stay informed, stay adaptable, and buckle up. These new rules are here to stay, and they're going to change the way things work in Florida's courts. We hope you found this deep dive into the new rules helpful. Until next time, stay curious, folks.